Salute you all, thanks for watching and thanks for being on. Today we are under the law of torts. And the topic that we are looking at, it is the topic of what? Of trespass to goods. We get trespass to goods. I want us to understand this topic in a way that actually we are looking at what you can answer. You understand? What is needed in trespass to what? In trespass to goods. One of it, what you have to know about trespass to goods has three categories. Okay, even before going to the categories, first know the essential elements that you have to know under trespass to goods. One of it, or the elements of trespass, one of it, for someone to be liable under trespass, he must have done the act intentionally or negligently. You get intentionally or negligently. You get negligently. There is a case of, if you read the case of Bell Canada versus Bannermount Limited, basically the plaintiff was held liable for negligent trespass, whereby he damaged the cables, the telephone cables of the plaintiff as they were doing excavation. You get. Then there is also the legal possession. The plaintiff must have a good title or a legal possession to the what? To the goods, for him to sue under trespass to goods. You get. So bear that in mind. And what you have to know under trespass, we have three categories. There is what they call trespass of a chattel without detinue or conversion. There is what they call conversion and detinue. So basically, note this up under trespass to a chattel. Basically, a chattel is something that's movable. We all know that when you apply some of the knowledge from land law about fixtures and chattel, a chattel is something that is movable. You get. Anything that is capable of being moved is a chattel. And trespass to a chattel is actionable per se. What do they mean by actionable per se? The reason that's why they say that it's actionable per se, there is no need of having proof of what? Of damage, to prove damage. There is no need. You understand? When you get to the case of Davies versus Lagos City Council, the plaintiff succeeded in trespass. You understand? Without proof or without infliction of any material damage, but just a mere what? Taking and transportation that amounted to trespass. So put that in mind. However, what you have to know, trespass to chattel being actionable per se, it is not a strict liability tort. Put that in mind. It is not a strict liability tort. You understand? So basically here in this case of the plaintiff is entitled to prove it and recover damage for it as the case may be. You understand? So put that in mind, or bear that in what? In mind. We have seen, as I've told you, about trespass to a chattel. Trespass to a chattel, basically what you have to put in mind, or what you have to bear in mind is that trespass to a chattel has many various examples. You get. For example, taking a chattel away, throwing another person's property, filling someone's bottle without the consent. Actually, it has many. So long as there's no proof of detinue and conversion, it has many as we shall look. There are many examples that I can't even finish. So long as there's no proof of what? Of conversion and detinue. But the mere example that is good, taking and transporting someone's property without what? Without, how can I say? Without authority, or without giving what? Without being given mandate. You get. So put that in mind. And what you have to know that plaintiff to succeed under this tort, for him, he must prove that there was intention or negligence on the part of the defendant. And the person who can sue, because that is the question, who can sue under trespass to a chattel? We have many categories of people that can sue. You get. Realize owners, bailees can sue, the lenders, assignees, trustees, finders, custodians, caretakers, advance possessors, executors, administrators of estate. I've read all the list, but what I want to elaborate more is on the issue of a finder. You understand? Who is a finder? About the list on a person who can sue. A finder is anyone, or bear in mind that a finder can be anyone that, take for instance, that a person that picks a certain thing from anywhere without intention of theft or without the intention of stealing. Take for instance, if someone throws a wallet in a hole and I pick it without knowing the true owner, at that time I'm the finder, you understand? And that time I'm the owner of that thing. So if someone takes away that thing from me, I can sue for trespass to goods. Because first of all, I'm the one who found it. So I become a finder and the owner of it. But if you become a finder once you don't know the true owner of the what? Of the good. Understand? So put that in mind. You get? Bear that in mind. For example, there is an example whereby it was a scenario in a case whereby a person picked a ring. It was a boy who picked a ring. So he took it at some of the jewelry shops. When he took it to some of the jewelry shop, the shopkeeper removed a diamond from the ring. Understand? So after removing it, this boy sued for trespass to a goods. So the court was like, did he has the capacity to sue? However, court held that he was a finder and he had the capacity to do what? To sue. So put that in mind about finders, or about the categories of people that can sue under trespass to what? To goods. You get? So put that in mind. Then we have what they call detinue. Detinue as another category. What do they mean by, or what do we mean by detinue? Basically, here what you have to bear in mind that when you follow the history of tort, we saw that there was a writ of detinue, and trove among others. So detinue here comes in a way that detinue is like, it is a tort, which is the wrongful detention of a chattel of another person. You wrongfully detain a chattel of another person. The immediate possession of which the person is entitled. You understand? The owner wants immediate possession of the title, but you have refused to do what? To surrender back the chattel. So it has two essential elements. First of all, the wrongful detention of the chattel of another person. Secondly, the immediate possession of the person is entitled. There must be immediate possession of which the person is entitled, and the wrongful what? Detention of the chattel of the other. So those are the two elements that drive detinue, what they mean by detinue. And basically, what do they mean by wrongful detention? Wrongful detention is like, take for instance, I've bought, I've taken my shoe to the cobra. When I pay the cobra fails to return back my shoe. That is wrongful detention. So the immediate possession that I'm entitled to is that I want the shoe to put it. Immediate possession is that you must show that you really want to use that good or that chattel by that time. For example, it is a shoe, I want to put it on. So you are denying me the immediate what? Possession of my what? Of my chattel. So put that in mind, or bear that in mind about detinue. And under detinue, there is the specific return of return. How can I say? That is basically detinue. So basically, what you have to know about detinue, some people say that it is a separate tort, but however, it is also a category to trespass to goods. And here, what you have to bear in mind, or what you have to put in mind, is that demand for return and refusal. Those are the two elements that drive detinue: demand for return and refusal. The owner has demand for return, but the defendant has refused to return. And the question is, who can sue for detinue? We have already seen this. Someone who has ownership or right to the what? Immediate possession of the commodity. The defendant must show that actual possession of the actual possession of the chattel has what? Has failed. You get? For example, as earlier told you, there is a case of Davis versus Lagos City Council. Under this case here, the defendant City Council wrongfully seized and obtained the plaintiff's tax cab. You get, the plaintiff sued claiming for damages. You get, however, the Lagos High Court held that the plaintiff was entitled to a return of the vehicle and the loss of earnings on the vehicle as a result of the unlawful detention. He was compensated, you understand, for the loss that he sustained. You understand? So put that in mind about detinue. Then when we proceed, that's what we have seen about detinue. Now there is what they call conversion. We get conversion. What do I mean by conversion, or what is needed by conversion? Conversion, basically, as I told you, conversion, we saw it as one of the ingredients under theft. Yeah, it was one of the ingredients, and we can apply that idea from that side still. So under here, or what you have to bear in mind, or what you have to put in mind is that when you look at conversion, basically conversion is like to interfere. There must be intentional and positive interference with possession. Intention and positive interference with possession of the what? Of the chattels. You get? And these are some of the essential ingredients or elements under conversion. First of all, any inconsistent dealing with the chattel is one of them. Another one is that to which a person, the person to which another person is entitled to immediate possession. You understand? Where the person is denied the use, the owner, possession or title to it. So bear that in mind. Thus, the owner can sue for conversion. You get? And there is a case of, is it Consolidated Company Limited? Yeah, Consolidated Company Limited versus Chattels and Sons, where a certain client instructed an auctioneer to sell goods that didn't belong to him. So he sued, the plaintiff sued the auctioneer for conversion because he sued goods that didn't belong to him. And these are some of the examples of conversion. One of it is taking, using, alteration, consumption, damaging or destroying it, receiving, detention, wrongful using to return, wrongful refusing to return the chattel, wrongful delivery, and wrongful sale or disposition. Fourth, those are some of the examples that can mean what? That can mean conversion. You understand? Conversion here, basically what they mean, or what they are trying to mean is that even if, let me give an example of a conversion. A conversion is something that's more that alters. Even if I steal somebody's phone, I put my cover. That is conversion. You understand? I steal a book, I cover it. That is conversion. You understand? So long as you have interfered in the possession of the what? Of the true owner, it will amount to conversion. Wrongful delivery, it will also amount to conversion. You get? So basically, note that in mind, or bear that in mind. For there is also whereby there's possession. Title is key. Possession of title is key. Just to know. And basically here the essence is the same. Who can sue owners, bailies, finders, buyers, assignees, trustees. And when you want to know the finder's rule, or the rule of finding lost property, or finders, there is a case of Parker versus British Airways. That case portrays the laws applicable on the finders. One of it, basically, a find of a chattel acquires no right over it unless it has been abandoned, lost, and he takes it in his or her care or control, among others. You understand? That is some of the rules that are applicable on the finders. You get? So basically, note that the case of Parker versus British Airways, that is a good case. So basically, that's what I can talk about trespass to goods. You get? That's what I can talk about trespass to goods. And in our next, we shall look at the defenses and remedies under trespass to goods or trespass to chattel. You get? And here we have been looking on what amounts to trespass, what amounts to conversion, what amounts to a chattel. I won't say that my cases that I've given, they are conclusive. I know there are many more cases, also in tort. Read cases as you can so that you may succeed in this course unit or in this particular topic. You understand? So thank you very much for listening. Thanks for being on. So I just wish you to be blessed. Thank you.